Case closed. Let's get drunk.
All week long.
All rise, order in the court. It is time. See some great.
It is time, Creed, and it's time for a judge who is also known as just jail court judge.
Yes.
To go into witness protection for his own safety and, well.
Actually, you know what's funny is up until the very second that we went live, I completely black. Like I couldn't even see a fake anything, but it looking a little bit better the second we
absolute darkness for the longest time, but yeah.
Well, we'll jump around a little bit. Got Clallam, is that how you say it? I think there's a couple of people in the church pews that look promising, but I say we start here and see what the hell court
with this former boxer. Nice nose. Real nice nose. Mm-hmm.
Yeah, that was interesting. I saw you guys talking about that with Judge Kim out of nowhere. Do you think that it's because of the that makes sense, the ice storms? Yep.
Yeah.
That makes sense.
I mean, maybe he'll be back on again today. I don't know what the weather conditions are around there, but
yeah, I saw somebody say they had a Lisa Herrick sighting, which is
oh my goodness.
Always
and I appreciate everyone who did send over text messages saying, hey, they're doing this. They're just unfortunately, we just can't do every single thing. Unfortunately. We have to cut it at some point in time. Are we all just going to sit here and stare at one another? What the hell are we doing here?
I'm not sure, but the jail court judge, that's what he looked like for the entire time before we went
live. We ready?
We're banker's ready. Offer is $8,000.
We're just going to call cause number
deal or no deal?
698832, 698833, 698834. 698835, 698836, 698837.
He put some bad people behind bars.
Yes, I am.
Sir, please raise your hand and be sworn. You swear to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
Sir, in all 6 cases, you're charged with the offense of terroristic threat causing fear. Which are
it's causing fear right now.
Misdemeanors, punishment fines of $0 to $2,000, 0 to 180 days in the Bexar County Jail. You understand what you're charged with and the range of punishment in each case?
Yes, I do.
State or their agreements.
In all cases, $0 fine, court costs, 48 days of confinement, credit for time served, time and money to run concurrent. All sentences to run concurrent, intend the judges be satisfied.
Who's talking?
And you understand on the 33 case, he only has 18 days?
I believe that is incorrect, Your Honor, because I see that he was booked on the 17th of December with bonds set at $1,000. And as far as I can tell, he has never been released.
I double checked it this morning. It is 48 days.
Thank you. Sir, in cause number 698832, how do you plead? Guilty, not guilty, no contest.
What you got? Not guilty.
No contest.
In 698833, how do you plead? Guilty, not guilty, no contest.
No contest.
698834, how do you plead? Guilty, not guilty, no contest.
No contest.
698835.
Wow, he's just gonna take it all, huh?
Guilty, not guilty, no contest.
No contest.
698836. How do you plead? Guilty,
no contest.
Not guilty, no contest.
Come on, mix them up with not guilty.
698837.
Throw in one guilty.
Just one.
Guilty, no contest.
No contest.
You understand on those no contest?
That dude looks
please,
so
I can
mean.
Still find
I'm telling you, he looks mean.
Yes.
Anybody force you, threaten you, or coerce you to make those pleas?
Your guess is as good as mine. There's a lot.
I'm not
them
sitting
freely
counting
and
it up.
voluntarily.
Something we know.
That is correct.
Anyone offer
That's
you
something we quit doing a
anything
long
other
time
than a
ago.
plea bargain to get you to make those pleas?
They did.
United States citizen,
Yes, I am.
waiving your right of appeal,
Yes, I do.
agree to plea by video and waive the open court requirement.
Yes, I do.
I'm going to show you it's been marked defendant's waiver and court's admonitions in each case. First, in cause number 698837. Did you read this document or have
Wow,
it read
you showed
to
us the
you?
documents. I like
Yes, I did.
Getting deep.
And is this your electronic signature?
Yes, it is.
That's a beautiful handwriting.
electronic signatures live on air.
Live,
channel.
yeah. If you've ever want to see one of those happen, who else is giving you this type of incredible content?
Right, we get to see live signatures. I mean, it's amazing. Angela, I hope you're captivated. What am I trying to say?
Captivated by this entire virtual signing. Also, mark your calendars. This is a beautiful day. When will the next time we see a beautiful virtual signing like this?
I think it's a first for We Got a Case, actually.
It has to be, of a long string of firsts.
Oh, God, he's got all of the numbers.
Oh, my Lord.
So Thirsty Thursday today for We Got a Chase, 405 East. Perfect timing.
Tons of drunkards. I mean, the stuff we're going to watch today, there's probably like 4 or 5 videos, but each and every one of these drunkards has their own backstory, a whole lore involved, a lot of resisting, a lot of people running from the law, and a lot of people laughing in the face of the law, Creed.
Okay.
So we're going to really have a good time, man. I might be a couple of Wormans in there, maybe, if you like the drunk Wormans. You get
Well,
a
they're
couple.
doing the signing. We'll just see. I don't think anything's going on. They just might be chatting.
Don't have to. What I'm thinking
Okay.
is, are you okay with us continuing this case for 6 months to see if you can not get another speeding ticket?
Absolutely.
Well, what is 6 months from now? We're in February already. What is that second month? So we can
Tricky question.
Continue this till the first week of August and see if you could not
Thank you,
get another
Alcoff.
speeding ticket.
I think he had that. I
So I
heard
can
the
dismiss
Chase was
it for you.
fantastic, huh?
I would absolutely.
So glad I
love
got
to
up
do
there.
that.
August what, Melissa? August 3rd. Did you hear that, Ms. Cadenas?
I did.
Hello,
August
Cole.
3rd, but I need you here. Don't
BP
forget,
check.
because if you're not here on August 3rd, then I'll just find that you committed it and
In
we'll
person.
find you.
Would you like me? Okay.
Angela, 9 months of member.
That's something to celebrate.
I know what you're doing. You're working for a living, but you probably weren't paying attention.
I was passing a truck and I didn't want to slow down to the speed and be right in front of him.
No, I know, but you got to be careful out there. I don't
Is
want
he making
I
excuses for her?
understand.
I know what you was doing.
And not to be,
I just
not
want
to
to
be
feel here.
so
Just,
forthcoming, but my brother just died in a car accident in
Oh!
September.
No,
So
I'm
I know
cool. I knew that.
how
very
that
sorry to hear
goes.
that, and I've
Thank you.
lost a lot of friends too from that over the years, and it's disturbing.
I've lost a lot of
Anyway,
friends that way. It
does
is.
It does make you let up on the gas a little bit,
Yeah.
So. All right, we'll see you.
Make
it Hilarious.
go. People die.
Yeah, people die.
Sorry to hear about
Constantly.
your brother.
I appreciate it, sir.
Thank you.
I mean,
Appreciate you.
I'm writing.
I hate to mute her real quick, but when somebody sends over 50 bones, that's right, 50 big ones over here from Cole in the PP, that deserves a silent hallelujah. There you go. I thought you were going to play hallelujah, but I quieted the room. Oh, yeah,
baby.
drink that in, baby.
Anybody got any porn music by any
Oh,
chance?
Beautiful
think-
stuff there.
He's either done with court or he's going to take a major dump.
Yes, it did.
One of the two.
And again, is this your
A little bit of
electronic
both it
signature?
is.
Yes, it is.
Wait a minute. He came back to. Oh, he had to grab the phone. He's going to dump. He came back, grabbed his phone, that was sitting right
Oh,
there.
yeah.
He's definitely. Thank you. For that.
That pot pie he had, leftover KFC pot pie he had, coming back on him. He's got to
I'm
get rid
still
of it.
appalled, absolutely appalled that you people are fine with the way that KFC makes those pot pies. I seriously I'm not. That is just not.
Look, I don't even want to brag, but I just had one right before the show.
I want a pot pie that's a pie, not a tin pot pie.
Today,
with a
it seemed
top.
like there was something on the sides, and I don't know because I was scraping it off. I was like, well, did they put something on the sides now? Because
They're good. I'm not gonna. They are good, but so is
I picked
Marie
the peas
Callender's.
out. I just don't eat the peas. And for
You don't eat
$5,
peas? You hate peas that much that you take the
Mhm.
peas out of a pot pie.
yeah. Not friends with the pea.
They don't really taste like anything, especially when they're in a pot pie.
So, are we still signing paperwork
Yeah,
over here? For God's sakes, man!
Again, amazing content today for We Got a Case. You guys are very welcome.
The virtual signing continues.
Again, while the virtual signing is going on, we'll jump over to Judge Hayes and Cowlitz.
First offense within 7 years, second lifetime offense with the blood alcohol content of 0.15 or higher. The court's
Thursday,
also found
Thursday.
probable cause to hold you to answer to a charge of an ignition interlock violation.
We're all thinking
Each one a gross misdemeanor with maximum potential sentence of 364 days in jail
I agree
and
with
a $5,000 fine. Would you like me to go over your rights at arraignment with you, or did you hear them when I was going over them?
Earlier, sir.
Okay, very good.
I can't afford.
Would you like me
these
to
there,
appoint
Pamela.
an
I
attorney to
wouldn't.
represent you?
Sir.
Aren't they
I'm
all
going to
gone?
conditionally appoint the Grimm Law Group to represent you. We're going to enter a not guilty plea on your behalf. That's conditional on you filling out an attorney application and filing it within the next week at the very latest. And so I'll hear
Your
from the
peas.
prosecutor.
How do you even taste them?
Conditions of release.
It tastes like
Your Honor, I'm
peas.
asking standard release conditions, alcohol conditions,
Boston
no
Market
driving
ones
without
and
license, proof of
supermarket,
insurance,
totally
and the
different.
required
I've never tried
ignition
them.
interlock
Oh.
device.
I was
At
thinking
this
that.
point, I will
Walk-in restaurant.
I've never been
also
into one of
recommend,
those.
because of the high blow and the prior DUI
The high
from
blow.
2008, that he report to offender services 2 times per week or post a bail.
The pasta carbonara that I get in
Mr.
Watkins
Frazier?
Glen at one of my favorite
Honor,
restaurants
we're asking for actually
has
standard
pizza.
release conditions
I'm
and for our client to be released on this matter. This is his first within 7. We don't show that he had any other criminal law violations prior than that 2008 DUI. So we're just asking for standard release conditions on this matter.
I'm somewhat of two minds in this case. Of a great concern to me is the fact that he blew 3 times the legal limit. And that he drove without an ignition interlock. On the other hand, the only failures to appear, and there's very few, are very, very old. And we haven't had any offenses for quite a while.
Is
Should
it
we
shredded?
worry about-
This is what I'm going to do.
Shredded's not bad.
I'm going to release you on your own recognizance. on
Should
the
we be
following
worried about
conditions.
his failure to
Here for a
appear?
pretrial on
Let's worry about
February
all
28th,
these
Wednesday
DUIs
via
he's
Zoom,
getting.
a readiness hearing on April 25th. at
Nobody's
2
going to die
p.m.
from him
Zoom.
not showing up
The
for
jury
court.
trial on May 8th at
Man's a
9 a.m.
drinker.
in person, have no criminal law violations. Report any change of address to the court clerk or your attorney. Immediately upon your release from custody, you must contact your attorney's office to give them your contact information. So they can call you back and tell you which attorney, you can make an appointment with that attorney. You'll have to do that very quickly. You must meet with your attorney before your pretrial. If you wait until the last moment, I'm not going to hear you complain.
Yeah, I hope he
They
pops
could
back
meet
on.
with
Love
you.
to see him.
They're just simply going to set a bail and put you in jail. And I'm not
Morning.
hitting on you particularly. I do this with every single person, okay? Now, further conditions. Do not consume alcohol or recreational marijuana. Don't use controlled substances unless prescribed by a physician.
You know, if I would have looked
And
at
then
this
use them
guy and
only
you
with
asked me what he did, I wouldn't have.
Do not
the
enter
part. I
any
would have thought of
tavern,
vampire
bar, lounge, liquor
immediately,
store, or any area where the
That
sale
or
and
a
consumption
wife
of
beater
alcohol
or
is
something.
primary activity. Do not drive without a valid license or insurance. Do not drive without an ignition interlock. On our pretrial date, on April 25th, I must have filed in this court or before that date an affidavit that either states that you have an ignition interlock or that you're not driving.
Very
If I don't
50-50
have that
with
affidavit
Pete,
on our
in the
pretrial,
chat.
I will find a violation and then I will.
Say
send a bail
the
demand.
decisive.
You must report to offender services.
Very quickly, they're still signing the Jesus Christ. Just an update. Just wanted you to know.
Can you hear me? Okay. They're on the 3rd floor of the courthouse and you must meet with them 2 times a week. You must submit to and pay for a urinalysis test or a breath test at the discretion of Offender Services. If they have reasons to believe that you violated any of these conditions, they have the authority to take you into custody. So we'll send over all this paperwork for you, and it sounds to me like they are going to process you out.
And it sounds like you might want to stop drinking.
You a-hole.
Yeah, that's the pretrial.
He's gonna kill somebody, I'm telling you.
No. Oh, I'm sorry. I set the wrong date on the pretrial on the ignition ruling. That's to be done on or before February 28th, 2023. That's the pretrial date. I've got to have that affidavit. Your attorney will help you with that. If you have any questions, okay? Do you have any questions?
No, I'm just a little confused, that's all, sorry.
Okay, about what?
What?
You put
Just the
Doritos and beef
whole thing
jerky
tonight,
into
the
your
dates and
burgers.
everything.
Yeah, we've got them all written down for you.
That's fine, I'll find a way to make it work.
Okay. Thank you very much, Mr. Betancourt.
Sir.
And that's it for us.
Betancourt.
Thank you, Council.
Isn't that Nino
Thank you.
Betancourt? Wasn't he the guitarist for Extreme?
Oh my God. That's, I mean, that's really.
We're still signing paperwork, by the way. Paperwork.
Something
Very
going on
important.
over in Licking.
The pre-screening, you check each
It's
eye
D.
twice.
Thomas.
Lack of smooth pursuit, you start at the center. You go out, you come back across, 4 seconds across, check each eye twice. You're looking for involuntary jerking the eyes while you're doing that.
Jerking what?
Now,
Eyes.
let me stop you right there. I probably should have asked before. What kind of training have you had to administer these tests?
So I've had basic police academy training when we have wet labs in the police academy. We practice on live, individuals who are under the influence of alcohol.
D. Thomas.
Further there,
He's Ken.
I have done
Peace and love. God.
Oh, wow.
Sorry, Dolphins fan, if you're here.
Peace and love. Peace and love.
BAC Data Master. We go over a little bit of that in there.
Dave Thomas.
And then our department puts on the refreshers for the SFSTs and the HGN and stuff like that.
You were trained on the 2018 manual.
Correct.
And that's the NHTSA manual.
Yeah.
And you didn't do the studies, but did they make you familiar with the studies behind the whole HGN type?
Yes.
He seems real worried
they
about what's happening
give
in
you
court today while he's
a
all
decent
slumped
knowledge of it.
down like this.
Now, okay, so we've been through.
Kicks are on point, though.
What's the next portion?
Are these witnesses?
The next portion would be distinct and sustained nystagmus at maximum deviation.
What the heck does that mean?
It's where they again, same as the lack of smooth pursuit. They look at the tip of your stimulus. You take the eye all the way out to the maximum deviation where you see
Look at the
white-
tip of my stimulus
all you see
screen.
is the white part of their eyes. And you
The
leave
white
it.
or the colored part?
The colored part. I'm
Okay.
sorry. You leave it at maximum deviation for anywhere up to 4 seconds and up. So where you're looking for nystagmus at maximum.
Yeah, I got it time
deviation
served. We're
while
going to
the
watch
eyes
it
are
in
sitting
just a little bit.
at maximum deviation. And then you come back, you check each eye twice, and you do that in each eye twice.
Thank you,
And
Tom.
the last portion of it?
The last portion is nystagmus prior to a 45-degree angle. Same, you have them follow your stimulus, and you're looking for nystagmus prior to 45 degrees.
How do you know what's 45 degrees?
You just kind of pretty much you just estimate it with.
What's all this
the
fancy
eyes
talk?
to moving your finger out.
On the first part, the lack of smooth pursuit, how many clues are there on just that portion?
Hello, Janet.
On the lack of smooth pursuit, on
Janet.
the first
Just it.
portion. Sorry.
Can't get away from drunks today.
Yeah. It's Thirsty Thursday, Mikey.
Obviously.
And the lack of smooth pursuit. I'm sorry.
Are there 2 clues?
Yes, there are. There's 1 clue in each eye.
Each eye.
Yeah.
And the next portion.
Same thing. 1
Is
clue
that
in
all
each
you're
eye.
looking for? When
So
you're doing this
1
thing,
clue in each eye for a total of
he-
3 clues.
there's really only 1 clue that you can get.
total
That
of
is
6,
basically what he's saying. That's
And 4 out of 6, what's the significance of 4 out of 6?
It's interesting because
We
There's
we
some
see it so much,
controversy
yeah.
for like a long time.
Very long time.
When you administer the
Very
test,
long.
now we can't. See,
But
you
also
hear
when your
yourself
head,
video,
when you tell them that their
we
head
see
can't
the
move,
actual
that's got to be a clue too,
test
right?
very well, even your back.
Other
I
than
guess
when you're
just
looking-
general following of
In
directions is
any
probably a
event,
big
you
clue too.
conducted that on the defendant. How many clues did you get?
I got a total of 6 clues, 3 in each eye.
All of them. Is that what prompted you to go on to the next test?
Correct.
And the next test, I believe, was the walk and turn.
Sarge,
8 clues
Erica?
on that.
Hey, hey,
Yeah,
hey.
there's 8 clues in the walk and turn.
Now, how do you conduct that test? I mean, how do you instruct them?
How I instruct them, I like to ask them if they've had any prior leg injuries, any medical conditions, if they're on any prescription medications. I ask for leg injuries or anything of such, because I want to make sure that they're able to walk in a straight line without any discrepancies.
Again, I don't have any
And
injuries.
if they
but
are,
I'd
if
probably
they do
have
have prior leg
issues, so
injuries,
I know.
I'd like to be
Why wouldn't
aware of it
everybody
so
like,
I
yeah, I
can
got a
get them
bum
to
knee.
do the
Oof. Goes out all the time.
So what I have them do is,
I
if
still don't
there is
understand.
not a straight line,
I wish you
in front
could
of
just
me
take a
at the
breath
time,
test.
what I have them do
That
is I
should be
have them
the
imagine a straight line in
first
front of them.
thing.
All
What I
of
have
this
them do is
stuff.
place their left foot on
Can
the
you imagine
line,
how many
right foot
drunks have
touching
actually
heel toe
gotten
in
a
front of
really
their
good
left foot.
lawyer and got off because of inconsistencies
And I have them put
in
their
those
arms down their
tests?
sides.
You know what I mean?
And then what I do is I tell them to remain in that position to the best of your ability until I tell you to begin. Don't start until I tell you to begin.
Was the
And it
defendant
holds
able
the
to maintain that
plexiglass.
position?
Coronavirus.
He did break the starting position.
Coronavirus. You know.
when
Keeps
I
all
told him
the
to, or
courtroom
when I
in check.
told him not to.
Okay, go ahead.
And then what I tell them to do is I demonstrate it. I take 3 steps. It's per the NHTSA manual that we take 3 steps. We don't conduct the whole 9 steps. And I go over a brief example of what to do.
I guess we'll get to that part in a minute.
3 steps. I
The
take
blowing.
my left foot and I start that with my first
Yeah.
step. And I touch
Slight
each
leg
toe,
injury.
heel to toe. And I tell them when you get to your 9th step, leave your 9th step planted and take a series of small steps, turn in the other direction, and take 9 steps back in that direction. And then when I tell them to do it, maintain, stay on the straight line, touch heel to toe each step, arms down your sides, make sure you're looking down at your feet at all times, and you're counting your steps out loud. And then when I tell them to start, I tell them not to stop. Until
He's super chill, by the way.
Demonstrated the test at least 3 steps up, turn.
Correct.
This is how he is with.
Yeah, we've seen him a million times.
I think he's the only one in all of Lincoln County.
There's a good chance.
Iowa golf
Now,
with Lisa.
he-
It was a
He
hard
did something
fought
and then
battle.
took his shoes off. Did you allow him to restart the
It was
whole
a
thing?
bloodbath.
Hey, Rochelle.
Yeah, he did take the shoes off and he did restart.
Oh,
And during that
was he wearing
time,
heels?
I guess I wanted to ask, we've already talked about moving his feet while he was in the instruction. Did he
dude
touch
can
heel
dance.
toe on all the steps?
No.
Did he ever
Show
raise
you all these
his
steps.
arms or step off the line while walking?
Yes.
And the turn, it's real hard to see the turn, but because it's kind of buried in the shadows. But how did he do his turn?
His turn was his front step did not.
He did a
stay planted.
pirouette.
It was more of a shuffle between both feet to turn the other direction.
And well, I don't know how to describe. Did he take the proper number of steps out and back?
No, he did not.
And any idea how many steps he took going out?
I believe I counted 18.
Is there no video?
18.
Made a turn and came back
Yeah,
18.
yeah.
Did they? Oh,
Did
they
you tell
couldn't do
him to
that. I didn't
only
know.
count the left foot for steps?
I did not.
When you were demonstrating, do you recall whether or not you were doing your left one first and counting 1, 2, 3?
I did, correct. Yes.
Do you recall whether or not he was counting along with you when you were demonstrating that?
No, he was not.
He was not?
So,
Haven't seen old Judge Stansbury in a bit. And it's still weird to see him in a setting of an actual case rather than talking to everybody.
There's the video up there on the big screen.
Oh, good. We're going to be able to see it.
Probably if we
Yeah.
stare very hard at that and it doesn't change. Sure.
in case you ask to step out of the way. Now, when I tell you to begin, don't stop until I tell you to, okay?
Roger, go ahead and pause that if you would, please.
What's she saying?
Trying to refresh his recollection.
Well, he just indicated that he didn't need his recollection refreshed, so I'll sustain the objection.
Okay, so you don't recall.
Correct.
Okay. Did he do this test?
Did you see her act? She just goes,
He did not.
Recall approximately how many clues you got sitting there?
On the walk and turn, I
Yeah.
believe I got 5 out of 8 clues.
And then the final one.
And we've heard
was,
people
the one
count
leg
those
stand.
out, by
How
the
was
way.
that
They'll be
administered?
one,
The
two.
one leg stand. His, it's a high traffic zone, so I waited till there was no cars coming around. What we have them do is, I've already asked them if they have any leg conditions, and they say no. So I don't find it necessary to ask the question again. What I have him do is put his legs aside. And
well, the dude was drunk. You
put his
got
legs together and his hands down to his sides.
I would go with
And
the
then when I tell
defense
him
of
he's gonna
being
pick a foot of
fat
his
and
choice,
clumsy.
He's going to raise it approximately 6 inches off the ground.
I'm not saying this guy's
And-
fat, but he is overweight.
And he doesn't have his shoes
look down
tied
at your
properly
foot,
either if he had them
and you're
that
gonna
way,
count
with a
in the following manner:
giant tongue hanging
1,
over
1,000,
like
2, 1,000, 3, 1,000, until I tell you to stop. And then once you start, don't stop until I tell you to.
We're not sure.
And then I
We're
ask
waiting
him if
to
he has
see.
any questions, and he states
It's a possibility.
No, he understands, and then I tell him to begin.
And if he has any questions, whether it's on the walk and turn or the one leg, you try to answer those questions.
Yes, I do.
And if you saw the video, he had a number of questions.
Yeah.
What about putting the foot down? This is a time test, right? The one leg stand.
Yeah.
It's 30 seconds?
Yeah.
You're not supposed to put your foot down. We heard that, but if you do.
Thank you,
what are
Mountain Brooks.
supposed
Good to see you.
Glad
Raise
you're
your
here.
foot back up and keep counting in proper order. Don't restart counting. If you have to put your foot down, raise it back up and continue counting. Don't restart.
Okay, and we saw in the video, he did restart a couple
It's up
of
there.
times.
I had 4, I believe.
We'll probably only hear
In
the
any event,
audio, I'm
there
guessing.
are how many
Yeah.
4 clues on the walk or the one leg stand?
Yeah, there were 4 clues.
Recall how many you observed when you watched this,
2.
and what were they?
Putting his foot down and
Again, I
he
would,
was using his arm.
if I was the attorney, I'd say he's chubby, Your Honor.
Towards the end
Yeah,
of the thing.
He failed gym
So,
class in
You
high
done
school
all
3
those,
times.
You know
Your
why
Honor.
he was pulled over. You made your physical observations and administered these tests.
Yes, and he went to
What
18.
did you do?
At that time, based
Rot.
on my observations, I didn't feel that he
Good old
was
rot.
fit to be operating a motor vehicle, so I placed him under arrest.
And I think we saw OBI.
Yeah, operating a motor vehicle.
Under the influence.
Thank you.
Is he the worst? I hate to use the word. Is he the worst impaired driver you've ever seen?
No, he's not.
Would alcohol affect
Kind of
different
question
people
is
in
that?
different
That's
ways?
kinda-
It does, yes.
The amount of alcohol based upon your training experience, would that affect how people act?
Yes, it does.
Why would you ask that unless he was the
And in your
drunkest he'd ever
opinion,
seen?
you consumed enough that you didn't think it was appropriate for him to operate that vehicle.
That's correct.
Once he was placed under arrest, are you familiar with the BMV 2255?
Yes, I am.
What is that form?
It's a form that we read to the person after they're placed under arrest to advise them of any potential license suspensions that they may incur.
Awesome. There'll be a quiz tomorrow,
What
Mount.
is
So
the
be ready.
limit?
Be
of driving in
prepared.
the state of Ohio?
It's 0.08.
And if he would have submitted to a test and tested under, would there be any license suspension?
Yes, there would.
If he's under?
Or no, there wouldn't. No, there
Okay.
wouldn't.
And if he's 08 or higher.
I mean, that's why we've got
well,
DUI lawyers,
it's not
right?
really a quiz
Yeah.
On the approach.
You may.
Let me hand you Plaintiff's Exhibit 2. Do you recognize that document?
Yes, I do.
What is that document
That's the BMV 2255.
that was used in this case?
Oh, please don't have to
Other than the
electronically
fact
sign
that
it.
It's a front and back page.
We've got our
Is that
fill
true and
so
accurate
far
copy?
today.
Yes, it is.
And if I can hold that up, what portion do you read to anyone really, but including the defendant,
The top section.
that top section?
Correct.
And then do you review anything down here?
Voice is
Yeah,
Carrie.
the
Good to
license
see you.
suspension.
Now, if I
Yeah.
took the test and tested above 0.08, and I'm a first-time offender, how long would my suspension be?
Buongiorno.
And if I refuse?
It's 1 year. Or,
Yeah.
sorry. I'm sorry.
Roughly off that.
God, is-
At
did
some
somebody just
point
fall
in time,
downstairs?
however, You became aware that the defendant was not a first-time offender.
Correct.
And what's the suspension there with one prior within that 10-year period?
That's 1 year.
If he takes the test, and how about if he refuses?
It's 2 years.
And then
Now,
they just draw the blood, right? No matter what. When you get back in, I would
During
imagine.
the course of your investigation, you got his name, his birth
I don't think
date,
every
Social
state
Security number.
enforces that,
If you look
though.
at Plaintiff's Exhibit 3, does that appear to be a certified copy of the DMV records
Yes, it does.
for the defendant?
The attorney looks like Big Van Vader, by the way.
I like him. We've seen a lot with
Retrieve
him.
that again.
I like what because he's a bit of a smartass.
Mhm. And he likes to play dumb, like, "Oh, well, what is that? Can you explain that to me?"
What is the first conviction listed there?
And say OVI alcohol.
And date of conviction?
3/4/2021.
And I believe that was in Franklin County.
That is correct.
So there was in fact a prior conviction.
Yes.
So when you read him the BMV 2255, did you ask him for any sort of test?
Yes, I did.
And there are 3 tests: alcohol, breath, blood, and urine.
Yes.
What test did you?
No, I'm guessing because he refused the.
I asked him if he would take the breath test.
And what
Okay,
did
so
he
he
say?
asked him.
He stated no.
He said, "Uh-uh."
Yes.
He refused. I'm guessing that's why we're here
After
today.
he's been read that BMV 2255.
What about blood and pee? Did we get any of that on the shoulder of the road?
If I can have just a moment, Your Honor.
You may.
Yeah, it's just crazy. Like the second that
Cross-examination,
you
Ms. Tome.
refuse is like automatically you're in trouble. You know what I mean?
Probably obvious, but fair to say you've never met Mr. Mitchell before that night.
Mitchell.
No.
Okay. So when you're making observations on his physical appearance, you had nothing to compare
Call
it
him
to,
fat
correct?
too, just like Mikey and I did.
Okay. And
That'd be my
you
defense.
indicated that
Yeah, by all means.
Thank you so much.
Yeah.
In the
Do you
middle of her asking
did you say
questions,
his
he
eyes
had
were
some
red?
judgment and throw it away.
Do you recycle,
His eyes
Judge?
appear to be red and glassy. Yes.
Okay. And you, again,
Sorry.
don't know what his eyes look like on any given day, correct?
Throw move.
And he did indicate to you later that he had taken a nap, correct?
Correct.
Okay. Now, when you approached him, he had pulled his car off the side of the road, correct?
Yeah, it was off the side of the road.
Well, I guess you didn't see him do that,
Yeah, yeah.
but
yes.
you saw the effects
Yes,
of it.
his
You saw
car
the
was
Her
outside.
yeah.
objection during the
And he had
video.
his blinkers on. Okay. And you engaged in conversation with him,
Cocky,
and
some
he
would say.
answered your questions. He answered your questions. Okay. You asked him to step out, and he complied with all of that. Okay. And so the first test you give him is the horizontal gaze nystagmus.
That's it.
Okay. And you indicated that
Like Jim Brewer.
well, we know we can't actually see what's happening with the eyes, correct?
In the video, yeah.
In the
correct.
video, right. The only person that could see what was going on in his eyes was probably you,
Toy mom.
correct?
Correct.
But what we can see is we
Toy.
see him standing there looking at you and following your directions. Now, you said that nystagmus correlates with alcohol consumption. And you learned in your training that there's other reasons for nystagmus, correct?
So I say, how can people
It
get
can-
women
you
pregnant
can
by
have-
accident?
Some people have naturally occurring nystagmus, correct?
Just don't
Yeah.
give a shit.
Young and dumb.
Now you
Oh,
moved
yeah.
on
Fear.
from that to
That's a
the
sin.
walk and turn, and you had a lot of discussions with him about the walk and turn. He had a lot of questions. Is that fair?
That's fair.
Yeah. And he said his shoes were spongy.
He did.
Yeah.
He had his
So
British
he
Knights
took them
on
off
that
at some
night crew.
point and kind of
BKs.
kicked him off to the side,
BKs.
correct?
Correct.
Okay. And you gave him the instructions, and he,
Yeah, that's what it sounds like. Golf and guns.
well, I believe, you said to him I believe if you can't just stand there while I'm giving the instructions, just do your best, something to that effect.
Correct.
Okay. So for him to break stance would not necessarily be a clue, correct?
Is she going to talk about the weights?
It would still be.
I would.
But
Is she getting
It'd be a
there?
clue, but I guess it'd be with permission. Is that fair?
it would be fair.
Okay. And I think he indicated at some point that like
Dick
he's
Harris.
a bigger guy and maybe that would be hard for him.
Dick Harris.
You had that discussion with him. Okay.
Yeah.
So he did not take 9 steps,
I
correct?
miss Meg.
Correct.
The goal was for him to count every step. Right foot, left foot,
Yeah,
right foot, left
he
foot.
went 18.
And fair to say he apparently didn't understand that.
Oh, is that what it was? Was a
Because he
misconception?
counted every other step, correct?
Misunderstanding.
That's correct.
Yeah. So he
He
actually
counted
took
every
9 times 2 steps.
He's bad at math, Your Honor.
He took 18 steps because he counted only his left foot.
I thought I heard it. We kind of talked over it.
correct.
She did ask
And
us,
you
talked about the
think
weight
that-
and
well,
if that makes a difference.
That's not how you're supposed to do it, right?
Correct.
Okay.
Cole, thank you. And here's another silent
So he-
hallelujah.
In effect, did twice
Thank
as many steps as he was
Thank you.
supposed
Thank
to,
you.
which was wrong
Right.
according to the instructions you gave him. Okay.
Bring it
But
on,
while he
man.
was
Bring it
doing
on.
that, he kept his arms down, correct?
He did until he came to his turn, and on his way back, his arms broke up.
Okay, so at some point while he's walking that straight line, he raised his arms up. Okay, but the first, I guess, 18 steps he took, he did not raise his arms up.
That's correct.
Okay, and fair to say that walking
Yeah.
a straight line, one foot in front of the other,
Be
it's not
white.
how we walk in normal life, correct?
That's correct.
It's, I don't want this to be too much of a stretch, but the only time we really do that would be if we were walking like a railroad track or a tightrope or something like that, correct?
Correct.
And in fact, if we would do that, we would use our arms for balance. As a kid, did you ever walk the railroad track?
I did.
Yeah, or a balance beam, I guess.
Well, I was in
Use your arms
gymnastics.
for balance. Now,
I've got a defense of the old railroad
you
track.
testified that alcohol affects people in different ways.
It's a great plan.
Yes, it does.
Yeah. Okay. And because everybody's different,
That's correct.
everybody has a different size, and I
Uh-oh.
think
Fat
alcohol can
defense.
sometimes affect males and females differently. Correct.
Mhm.
Okay. And Mr. Mitchell is male, and he's a larger man. Correct.
That's correct.
Now, with regard to the arrest, he complied with the arrest. You said put your hands back. He
Absolutely.
did.
Yeah.
You put the cuffs on him, and you continue to have discussions with him. And in fact, he asked you, "Am I going to do another field sobriety test?" Do you remember seeing that on the video?
I believe I did.
And I think you said something like, "I wasn't sure if you were joking."
Can you ask for a redo?
Maybe you didn't. I'll
don't think you
retract
can
that
do
part of the
that.
question. Okay, so he's under arrest, and was he placed in your cruiser or Officer DeJesus'
He was
cruiser?
ended up placed in my cruiser.
Okay. And then, so he's cuffed and sitting in the back seat of your cruiser,
That's correct.
not free to leave. And that's when you had a discussion with him about taking the breathalyzer test.
Correct.
Okay.
I would think sometimes if you got the blood alcohol, because we've seen tons of cops get arrested for DUIs, and they always reject taking breathalyzers. It seems maybe they feel like you got a better chance of beating it if you don't do that.
Just one
If
second,
you,
Your Honor.
as compared to if you do, and they've got that card against you. He's larger than normal. He's above average, Pike, in several departments, including alcohol consumption. I knew some big people that couldn't.
All right, redirect.
What?
Mr. King.
Abruptly, we just stopped like that? Really?
You still have some water, officer? I do.
Just a few
Stansbury
more
handed
questions,
water.
officer. Number one, you were asked that when you were having the initial conversation of the defendant in his vehicle, he was able to answer your questions.
Correct.
Remember him telling you he hadn't had anything to drink?
Thank you.
You also, I believe, in your training with respect to the HGN, any other conditions other than
Oh,
alcohol
no.
are rare?
Correct.
You,
That's
and
why
there's
people
something
being
called
larger than
rotational
average.
nystagmus. You weren't spinning this guy around, were you, at any point?
No.
There's, and I forget the name of it, but there's one, if you put cold water in someone's ear, it can cause it. You weren't putting cold water in one of his ears, were you? Were you administering the test and observing the clues as you had been trained?
Yes.
I don't
No,
know
I
if
think
you
he,
can have
I think
a
he
clue
hired
with
this one, I'm
permission.
guessing. Maybe, I don't
You're
know.
supposed to stay in the walk and turn in a certain position.
Correct.
Some people can't stay in that position.
That's correct.
Whether you say, okay, I'm going to go on with the instructions, it's still a clue.
Correct.
18 steps would be a clue, would it not?
Correct.
Stepping off the line,
Correct.
not walking heel to toe.
Correct.
And I believe previously you had indicated he did all those.
Correct.
Is driving a divided attention skill?
Yes, it is.
In what way?
Objection outside the scope of cross.
I'll allow it.
Go ahead.
Oh,
Uh,
take
you
that.
have multiple operations. You have to steer the vehicle. You have to look where you're driving the vehicle. You have the acceleration of the vehicle, the brake of the vehicle, other traffic on the roadway, stop signs, red lights, green lights.
Keeping the vehicle
Correct.
within your lane of travel?
Yes.
Are standardized field performance tests also divided attention
Yes.
skills?
Yes.
Regardless of how you normally walk,
Said something about 2 years. up
there are
to 2.
certain things you instruct
Yeah.
the defendant to do. Would you say?
So
he
it's
was
a good
able to
chance
do
for that.
I was having flashbacks to that Asian cop that was on it. Remember that day?
Still, he
was
was under the influence of alcohol.
Yes, I do.
Nothing further.
Any recross?
Did you see her abruptly just end after she leans over and talks to her? Okay, nothing further.
Yeah, weird.
Driving is a divided attention skill.
Correct.
Okay. And now you didn't actually observe Mr. Mitchell driving.
No, I did not.
Okay. So what you did observe, however, was him in the driver's seat, correct?
Correct.
His vehicle appropriately negotiated off the side of the road, correct?
Correct.
Okay. He was
They mean
able
you didn't see him
to
driving.
open his car door when you asked him to get out.
Correct.
Okay.
Been parked when he rolled up
So-
on it.
Everything that you observed about Mr. Mitchell in his vehicle was lawful and accurate, correct?
Lawful, yes. Accurate, yes.
Thank you.
All right, officer, you may step down. Thank you very much. Any additional witnesses on behalf of the state?
Does big boy get on the stand?
Any objection to 1, 2, or 3?
No, Your Honor.
All right. States 1, States 2, and States 3 will be admitted without objection. Does the state rest?
We do, Your Honor.
And counsel approach, please.
Oh, we could have a little chat, I think.
Well,
And we're muted. Interesting. So what do you think? Oh, wow.
Oh, he's going to just go
Like-
for the talk. He pulled it down from the talk for a second. I don't know. Maybe he was getting everybody's lunch order. Maybe somebody's going to Bojangles and to see if everyone wanted dirty rice or white meat, dark meat.
Maybe they wanted to discuss the fact that they take their recycling really
Okay, well, ladies and
serious there,
gentlemen,
and, they do clear plastic only.
The defense is not going to call any witnesses today. So at this point, we're at the
That's
conclusion
it?
of the evidentiary portion of our trial. So therefore,
I don't
the only
agree
thing
with
that's left to do before we get things to you is the closing arguments of counsel, as well as my final instructions. And we have to tweak those a little bit. So we're going to take our final recess of the day before you begin your deliberations. It's approximately 1:45
There's a
now.
jury?
So we're going to reconvene at 1:55.
Oh, wow.
And as I said, we'll have closing arguments, final instructions. But I would remind you, you're still not to discuss the case among yourselves or let anybody discuss it around you. You still have to tell people you're not allowed to tell them anything about it or even what type of a case that it is. And I would
Dude went
sternly
all
remind
out,
you,
huh?
It is your
Yeah, he
sworn
did.
duty
He's
not to
like,
form any opinion on the case.
I want a
until it's
jury
submitted to you.
trial,
With that,
please.
Ms. Kyle?
Nobody else saw there was a jury there, right? The others we've seen are sure as hell wasn't.
I didn't know there was a spot over there for one, to be completely honest with you.
Holy crap. I thought we were going to get that. I thought that was cut and dry. We're going to see the end like now.
I don't know. He said we're reconvening at 1:55. Is that what he said?
Yeah, their time, though. Are they an hour behind us? Is it an hour? What time is it?
Maybe he's at 12:55. To be sure, he's not going to take that much time off. He's just got to poop, probably.
What time is it in Licking, Ohio?
The time in Licking County, is 1:46 p.m.
So it's only 10 minutes? Are they coming back? Okay.
All right. So how about so this video that Tom Surf sent over?
Yes.
It's 11 minutes. So
perfect
timing for this.
Good.
We'll get to it. This is what happened. This is actually the guy right before the guy we started watching, I think.
Okay. All right.
So we're gonna see this. He says he's labeled it bad behavior, bizarre bad behavior. So what's going on?
738, State of Texas versus Tyler Daugherty.
He's right here, Judge. That on the blue decal. Okay, stop talking to yourself.
Sir, please
Talk to the judge.
Sir, please raise your hand and be sworn. You swear to tell
Stop talking to
the whole
yourself.
truth, nothing but the truth to help you God?
Yes, sir.
Sir, you're charged in both cases with the offense of criminal
DDP.
trespass, Class B misdemeanors, punished by fines of $0 to $2,000, 0 to 180 days in the Bexar County Jail. You understand what you're charged with, the range of punishment in each case.
Yes, sir.
Okay.
He's possessed by demons.
You can put your hands down.
Oh my
Mr.
God.
Daugherty.
Sir, you understand what you're charged with in the range of punishment.
Yes, sir. I think so.
State, is there an agreement?
In cause number
that correct?
700738, $0 fine, court costs 17 days of confinement, credit for time served, time and money to run concurrent. State will take into consideration and dismiss cause number 700054. Intend the judgment be satisfied.
Is that the agreement?
Yes,
Look,
sir.
Brian down there's laughing.
Sir, to
He's
that
kinda
offense, how do you
smirking.
play? Guilty, not guilty, no contest.
It's no contest, Mr. Daugherty.
Sir, you're going to have to take your mask down and speak loudly. How do you plead? We can't hear you.
Guilty.
It's no contest, Mr. Daugherty. That's what, but it's the same as a guilty plea, but the
Oh,
paper
wow.
says no contest.
No contest, sir. I believe no contest.
You understand on a no
He's just
contest
killing
plea,
it.
I can still find you guilty?
You have to say
What is
yes.
he doing?
It's the same as a guilty plea. No contest, same as a guilty plea. We went over this.
He's,
Mr. O'Donnell?
yes, I say yes.
Anybody force you, threaten you, or coerce you to make that plea?
I just popped a very long and
Sir, you
lengthy
got to speak loudly.
I think yes,
link
sir.
for you to click.
Sir, anybody force you, threaten you, or
No.
coerce you to make that plea? Making it freely and voluntarily.
No, sir.
Sir, please listen to the questions. You may making your pleas freely and voluntarily.
Look at the guy down there.
Mr. O'Donnell, I'm beginning to think he might need to visit with Judge Carruthers.
I understand, Judge, when we had our talk, my client wasn't like this. He said he wanted to accept the offer. No one's forcing him to do this.
Sir, we're going to try again. Anyone force you, threaten you, or coerce you to make that plea?
Loud, sir, loud. It loud, no. No, sir.
Making it freely and voluntarily.
Is that what he's doing though? Say it loud.
Yes.
Anyone
Yes,
offer
yes.
you anything other than a plea bargain to get you to make that
You
plea?
win it, yes. Someone wins. Who wins it? Who wins? Someone wins, yes. All right, Judge, I think someone wins, yes. Who wins? Yeah.
All right.
He didn't start behaving this way until he got in front of the computer.
Oh, well, bring him back in front of the computer for a minute.
Are we insinuating that he's doing this on purpose?
He's insanity plea, Green.
Mr. Daugherty, here's the deal.
No
If
way.
you don't understand what I'm saying, I'm going to have to send you for a psychological examination and you'll be sitting in jail probably another 30 to 60 days until that's completed before we bring your case back. Now, if you want to continue to act like the way you were acting, I'm going to have to send you for that psychological examination. The deputies are telling me you weren't acting that way when you were talking to your lawyer. So now, if you would like to answer my questions straightly, I'll take your plea and you can conclude your case today and be released. And if you want to continue to act up, I'll send you to Judge Carruthers and you'll sit in jail until your psychological examination is complete. Which do you want to do?
What do you want to do? Yes, sir. Yeah. Sir, it seems like something just will not let me think correctly. I want to know.
Well, sir, if you're having a mental thinking problem when you're at the bench, I'm going to have to suggest that you're
having
a psychological problem. I'm going to have you
mental
examined.
correction.
So if you want to get out today, you're going to have to get coherent immediately. If you don't want to get coherent immediately,
In other words, if you're
I'm
acting
going
now,
to send
it's
you to
time
Judge
stop,
Carruthers for an
because-
examination.
Thinking.
So I'm going to try the question again. You making your plea freely and voluntarily? Got to speak loud, sir.
Just put the headphones on them, Judge.
Put the headphones on them. Make them listen to that crappy music Golden Slots plays during the show.
You mean like the Bee Gees?
Yes. That'll break them.
Sir,
Put those on.
you're making your plea freely and voluntarily.
Hang on, Judge.
All right.
Yes, sir. My plea is that. Hang on. Right now. Yes, sir. Yeah.
Sir, you're making your plea freely and voluntarily.
I wish, I could stay, please. I wish I could stay. That I'm asking, please. The longevity one day wins me.
Mr. O'Donnell.
I'm sorry, Your Honor. My client wasn't like this when I talked to him.
Did somebody
I don't
drug
know
him in
exactly what's
jail?
going on. If I could try again in the breakout room, maybe I can talk to him.
It's not
where
just the
he'll-
dude in the jail that said that he was not, acting this way. It's also him down there too.
So the attorney, both of them are like, look, he wasn't acting this way earlier. I mean,
Yeah,
he's
that's
acting
two
like
of
he's
them saying that.
completely insane. But I will, in this guy's defense, the crazy dude's defense, as he was walking in, the guard says, how about you quit talking to yourself and talk to the judge?
They are back. Let this well.
All right, let's go back and make sure we
We'll
don't.
come back.
All right,
We'll come back.
All
to
right,
that.
he's coming back. Here we go.
Everybody
Please be
stand up.
seated.
Now you
We're
sit.
back on the record in the James Mitchell case. It's 22 TRC.
We'll come back to him.
07664.
Closing
He's in the
arguments. I don't think
courtroom
they're going to take that long.
today.
I wouldn't.
Still with his attorney, Mr. King remains on behalf of the state of Ohio. The jury is not in the courtroom at the moment. We are coming back from our final recess before closing arguments and final instructions. Ms. Tome, I know that you indicated you were not going to be calling any witnesses or introducing any exhibits. However, do you wish to make any motions before we continue?
Thank you, Your Honor. At this time, I would ask the court to dismiss the case pursuant to Criminal Rule 29. That the
Boy, she's
state
really
failed
she's really
to
stretching on that one.
its burden to get the case to the jury.
Dismissal.
Namely, that there is enough evidence that Mr. Mitchell was operating a vehicle while impaired on the night he was charged. Thank you.
All right, any response, Mr. King?
No big surprise, but we would disagree. We believe that we have provided sufficient evidence.
And the Rule 29 is a test of the sufficiency of the evidence.
Gary.
The test is whether or not reasonable minds could come to differing conclusions based upon the evidence. And the court feels that the state has met that minimal burden. So for that reason, the Rule 29 will be overruled. Anything further on behalf of the defendant or the state for that matter before we bring in the jury for final arguments and instructions? Mr. King?
No, Your Honor.
Ms. Tome?
No, Your Honor.
Let's bring him in.
Well, they bring in the jury, on the last guy. That's a very interesting one. We'll definitely, we will jump back to that. I kind of want to see how this plays out since we saw so much of it, and we'll jump back. It's the first person that we've seen really come in and kind of act that
Like that, yeah. And with the judge and the attorney telling them, like, I don't know, it did seem like a little bit.
Please be seated. And the
You know,
record shows
forced
elected
hand
jurors are now
slightly.
back in the courtroom,
Yeah.
all 9 of them, and they are seated.
Guards
in jury
yelling in
box.
his face.
Mr.
Louder.
King, if you're ready for your summation, you may proceed.
Thank you.
What a waste of time this probably
Please,
was.
the court, counsel, ladies and gentlemen of the jury, we're almost done. I know you're tired of hearing me as much as I'm tired of hearing myself. But first and foremost, to prolong this a little bit, I want to thank each and every one of you for your patience, attention throughout this trial. Obviously, as I said on Boyd Deer, we come to a screeching halt. But for people like you who are willing to give their time, listen to the evidence, apply the law, and hopefully you've gained some sort of insight in how cases are handled here virtually every day, whether they're jury or not. If during the course of this trial I've made anyone upset, please accept my apologies, but don't let that impact on the actual evidence that you have heard and will have with you during your deliberations. Again, what I say is not evidence. It's simply a summation to what I believe the evidence points to and shows and establishes. I want to point out, though, that I would never intentionally mislead you, and I don't think Mrs. Tome would either. And by that, I mean, if I say it was a bright and sunny day out back on this date, I don't mean to do that, but you rely upon your own recollection of what the exhibits show about what the testimony was. Not mine, not hers, your own. With that being said, I'm going to try to keep this somewhat brief. There is no such thing as drunk driving in the state of Ohio. I told you at the outset, don't know what drunk means. The judge is going to give you the impaired driving or driving under the influence instruction. And listen carefully, because what he's going to tell you is it doesn't matter whether the alcohol was potent or mild. It doesn't matter whether there was a lot of it
He's laughing at
or
me.
a soft or a lesser quantity of it. It depends upon whatever amount consumed, what effect it had on the defendant's actions, reactions, mental processes, and whether or not the consumption of the alcohol affected the nervous system, brain, muscles of the defendant so as to impair to a noticeable degree his ability to operate a vehicle. He'll give the more formal, but that pretty much hits it. It's not how much would an ordinary person be affected by it. How much did it affect the defendant on this day? That being said, I said at the outset, a lot of the elements, the essential elements that I have to prove aren't really in contention. Whatever happened on September the 6th, 2022. It happened in the city of Pataskala, Licking County, state of Ohio. There's no question about who the driver was. Both officers indicated the defendant was the driver. Consumption, initially, the defendant told Officer DeJesus he hadn't had anything to drink, which was not true.
Slightly.
He also told Officer Thomas that initially, while he was seated in the driver's seat, he didn't have anything to consume.
Oh, they can.
Once
Yeah.
the Officer Thomas got him out of the vehicle and
definitely
separated himself from the vehicle, you know, there's no specialized training. He smelled a strong odor of an alcoholic beverage, a strong odor coming from the defendant, who then indicates for the first time, yes, I've been drinking. He can't tell you when he got to his cousins or relatives. He didn't think he had all that much. I think you'll see on the videotape, the body cam, but he can't tell you how many drinks he had or anything else. But it is 12:16 in the morning on this date. And he took a nap to sober up. I would submit to you, he probably should have slept a little bit longer. What effect did the alcohol, I think it was the cheap rum he identified it as, have on him? You can pick apart every little thing in the world, but you have to do what the officers have to do, which is apply what's called a totality of the circumstances. He wasn't arrested because he went left of center. outside his lane of travel.
Fat
He
guy,
wasn't at
11,
that point in
10:30,
time. No one
every night.
knew he had didn't have a license, a valid license. It's not the odor of an alcoholic beverage. It's not the red, glossy, bloodshot eyes. It's none of that. It's everything. Everything that you've heard about today that matters. That would include not only his driving, his inability to follow simple instructions.
I think
his
him and his
inability
lawyer think this is a
to
slam
follow
dunk.
demonstrations. Here's what I want you to do.
They seem a bit cocky about this, no?
And he can't do them. Why? I would submit
They
to you
paid off the
because
jury.
It was the alcohol.
Dairy
he's
Queen
nervous.
gift
Everyone
cards.
gets nervous when an officer stops you. He is so far out, not the worst impaired driver, but he's so far out that he had no business being behind that wheel at that time of morning. So he was arrested for everything, all put together. He was in, read that wonderful BMV 2255 you heard so much about, then you'll have a copy of it, which explains to someone who's under arrest what the penalties are. And he refused. He refused to take that test, which is another thing you have to ask yourself. Why would you refuse if you weren't under the influence and didn't think you would test? Those are all the A1A, the impaired driving. If you find the defendant is guilty of being impaired and operating that vehicle, then I would submit to you that the refusal with the prior conviction is nothing simple in this. It's jurors have a hard time, difficult time. It's hard work, but
Prior
relatively
conviction.
speaking, there's no doubt that
There you
as
go.
both officers testified, the defendant was arrested. You saw him handcuffed. He was read. Both officers indicate that he was read that BMV 2255. He was asked to submit to a breath test. He refused to submit to that breath test. And he does, in fact, have a prior conviction, certainly within 20 years. And it was on, I believe the testimony was March 4th, 2021. He was previously.
Oh, it's not that far ago. Wow.
He is
2
guilty.
years ago.
Thank you.
Ms. Toom, your closing argument?
Thank you, Your Honor.
So he knew what he was doing.
Good afternoon again.
So,
Yeah, this isn't his
Okay.
first rodeo. He
Mr.
knew
King
it.
talked about the totality of the circumstances. So let's talk about that. And let's talk about everything that Mr. Mitchell did right. Mr. Mitchell pulled his car over appropriately. Mr. Mitchell put his blinkers on. Mr. Mitchell engaged in a conversation with the police officers first at the passenger side. Mr. Mitchell unbuckles his seatbelt. He gets out his wallet. He hands his identification to the officer. Totality of the circumstances, we got to focus on everything. And when it comes right down to it, what did he do wrong? Pretty much counting. If you really think about it, he counted wrong.
And the
on a
fact that he
couple
was
of
drunk.
occasions.
that might have something to do with it.
His speech, perfect. No slurring. There's no allegation that he was slurring. He spoke perfectly. Everybody understood what he was
You just
saying.
did too.
understood.
Happy hour anytime.
He answered questions appropriately. Yeah, at one point he said he hadn't been drinking, but keep in mind too, he says, well, I was drinking earlier, I took a nap. And so he did acknowledge that he had consumed alcohol at some point in that day. And look at the video. He's standing perfectly straight. HGN's conducted. They say, oh, we see nystagmus here. We see nystagmus here. Well, we can't see it. Maybe it was there. Maybe it wasn't. I don't know. We have to focus on what we can see. And what we can see is a man that he followed those directions perfectly. So Mr. King's discussion of his inability to follow instructions, therefore he was impaired. I don't really think that's accurate. He does follow instructions. In fact, he
follows them too
questions
well.
the officer because
Does
he
it twice.
doesn't understand.
Is she going to leave this
It's like,
abruptly?
no, wait a minute. Am I
without
supposed
finishing
to
it?
do this? Am I supposed
like
to do
last
this?
time?
And, you know, he He asked him over and
can't
over,
believe
like, I
it
don't
was a
understand that. I
jury
don't
there for
understand
that.
that.
Rag monkey.
He drove his car
Monkey.
perfectly. He took his seatbelt off perfectly. He answered questions perfectly. In the words of Officer Thomas, regarding what he observed of Mr. Mitchell actually being in the car, everything was accurate and lawful. Are we applying a test here to determine if someone's under the influence or if someone is physically an acrobat, that they can walk essentially a balance beam
Waka,
on
waka,
the
waka.
floor, granted on the ground, not raised, but a balance beam without using their arms to balance. What are we testing here? We're testing for whether or not somebody is under the influence.
She's doing all right,
Again, the
John.
judge is going to instruct you on the law, but Mr.
Except
King
when
said
she
it. I'll say it too.
Abruptly stopped last week.
He's getting what he pays for.
If the consumption of
She's
alcohol
probably
so
free.
affected the nervous system, brain, or muscles of the defendant to a noticeable degree, that affected his ability to operate a vehicle, then he's under the influence. How take an honest look at this. How is this man's nervous system, brain, or muscles impaired to an appreciable degree? How is he impaired? Did he do the test right? Nope. I said that at opening. I'll say it again. He took 18 steps. Took twice as many as he was supposed to. How is his nervous system, brain, or muscles impaired to a noticeable degree? They're not.
Nope.
He answers the questions right. He does the tests as best as he can. He screws them up, but he doesn't screw them up because he's under the influence.
Frank.
With regarding,
feel like I could do a
regarding the
better job
refusal,
right now.
Mr. King says he's facing a longer suspension. Well, we know he didn't have a license to begin with.
Yeah,
And
exactly, Elizabeth Ann.
he's already under arrest. He did everything they asked him for 20 some minutes. He gave them his license. He got out of the car. He did his best to do what they asked with regard to his test. And now they've got him cuffed and sitting in the back of a cruiser. And they're going to say, oh, one more thing. Now you have to do this test as well. Well, I mean, come on. He'd done everything they asked. And he was put under arrest. Don't fall for that red herring, please. We talked about the burden of proof. Proof of such
You're being
character that you're
bamboozled.
willing to rely and act upon it in the most important of your own affairs. We all saw the same thing. And the police officer said, yep, there's enough here for us to arrest him. But it's up to you. Is there evidence here of proof beyond a reasonable doubt that he's under the influence of alcohol, as I defined it, as the judge will define it? Is it something that you're willing to rely and act upon in the most important of your own affairs? Something
Licking
important to
County's
you.
finest.
And that's what you see. It's like, yep, that is guilty. The most important of my affairs and what I saw here, guilty. I don't think it's there, folks. You take an honest look and listen to what this man says, watch what he does.
Should have put him on the stand.
not there.
I'm
It's
telling
not
you,
proof.
they really messed up by not
It's
calling
not
any witnesses. at all.
Evidence of impairment that you'd be willing to rely and act upon. It's just not there. It's a man who
Nope.
counted wrong,
Yeah, no.
didn't understand
Nothing.
some physical acts he was supposed to perform, didn't understand physical acts he was supposed to perform.
Physical
That's what they did.
acts.
It's not
Counting, not physical.
somebody
act,
who's
counting.
impaired and shouldn't have been driving. It's just not there. And I'd ask you to go back, take a look as much of it as you need to again, and return a verdict if not guilty. Thank you.
And your
Yeah.
rebuttal argument, Mr. King.
Thank you.
Could've done
Yeah,
better.
boy.
don't recall being drunk.
Yes, counsel and I have a difference of opinion about what you've heard and seen throughout this whole thing. First and foremost,
Looky here.
don't call the BMB 2255 form a red herring. It's red after someone's arrested. That's when it's red. Why do you refuse? You're afraid of maybe what it's going to show. That's why you refuse. You don't even care if you have an increased penalty. You're not going to provide it. She uses, again, the balance beam. This was a reasonably flat, level surface
Acrobatics.
with a painted
Don't forget
line
that.
on it called a fog line. He's not on a balance beam utilizing his hands for balance in case he would fall off. Alcohol affects people differently. The mere fact that he may not exhibit certain traits or circumstances, he didn't fall out of the vehicle when they asked him to exit. Some do. He didn't do a lot of things that some do. It's all different. And that's the point. Was he able to follow simple instructions? Absolutely not. Even when it's demonstrated, he can't do it. Beyond a reasonable doubt is not mere possible or imaginary doubt. You must rely upon it in your the most important of your affairs.
Oh, wow. Super duper late.
The guy that you saw in the video, should he have been behind the wheel of that vehicle on the date and time in question? Submit to you, he's guilty as charged. Thank you.
Yeah. ECW's guilty.
Well, ladies and
as
gentlemen of the jury,
charged.
you've heard the evidence and the arguments of counsel. The court and jury have separate functions. You decide the disputed questions of facts, and the court provides instructions of law. It is your sworn duty to accept these instructions and to apply the laws it has given to you. You are not permitted to change the law or to apply your own conception of what the law should be. You'll each be provided a written copy of the instructions to have with you during deliberation, so please do not concern yourself with trying to memorize these instructions. A criminal case begins with the filing of a complaint. A complaint informs the defendant that he has been charged with an offense. The fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charge.
No, and that's
an
the part
issue
you got to
on the
remember. He
essential elements of
drove
the
to that
offense.
spot to pull
The defendant is
over
presumed innocent
to
until
do the
his
right
guilt is
thing. As she
established
said.
beyond a reasonable doubt.
Catch
The
some
defendant must be
Z's.
found not guilty unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offenses charged in the complaint. Reasonable doubt is present when, after you've carefully considered and compared
Congratulations,
all the
you just
evidence,
added a browser.
you cannot say that you are
How was that?
firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would
We
be
don't
willing
need
to
any
rely
of
and
that.
act upon it
They're
in
just-
the most
they're
important
gonna
of his or
let-
her
I mean,
affairs.
that's where we're at now with that.
Yeah, he's just giving instructions to them. They're going to go to the back. They'll make their decision. Which, I mean, I'm no Judge Creed. But I'm pretty sure they're going to come back with a guilty.
That's what it says, yes, sir.
and back very soon, I would imagine. Let's jump back over to here.
He wasn't like this before, Judge.
Look at the judge. He's like, what the hell have I just had?
I'm going to send him back to the breakout room, and if you can't straighten him out to come back to the bench to take the plea, I'm just going to send him to Judge Carruthers, and he can just sit in jail.
Thank you, Your Honor.
Sure.
He's
playing right in jail for all I care, Credence.
Sir, you need to go back to your computer in the breakout room.
Okay, yes, sir.
You need to take that headset off and go back.
Done?
Wow.
Is he finished, or is he going to Carruthers?
No, we're going to see if Mr. O'Donnell can talk to him for
Who's
a minute or
Carruthers?
two,
I mean, is that
and
like
we'll-
a threat?
If he's still that way, then he's going to Carruthers.
I guess that's that, but wow. That dude, I'm guessing he's going to come back later. So if time served with
Oh, that
Phil
makes sense.
gets that special judge just for the crazies.
Mental health judge. Oh, all right. Are we we're gonna promise to try and catch this when they come back? I think we could probably keep an eye on it. It's gonna happen today.
Hell, I would think within like 30 minutes. They'll probably take
That's what I
like
would
lunch
think.
or something.
Yeah.
Or
Well, we
whatever.
keep an eye on it. Hopefully, get it recorded and have the just to see what happens. We saw a lot of it, which is good. All right, let's cut it there. He's again just giving instructions, and the jury's going to go.
But you know, we saw the wheels of justice turning today there in Licking County as this young drunkard, two-time loser, back up against the judge. So I would think he's going to get some decent time right at this next one, right? He's got to do a little bit of time.
I would think so, yeah. I would think so. All right, we'll see you at 4:05 for Thirsty Thursday, and maybe we'll have a little update at the end of it with this, maybe, or tomorrow.
Maybe.
We'll figure it out.
Well, we appreciate you guys. If you haven't already liked this video, please do so. Because right now, Creed's about to shout out these folks on this monetary monorail.
Shells, Cole, Flusha, Bigfoot, Snoopy Mayor, and Flusha again. Thank you guys.
So much easier than yesterday, right?
Very much. Yeah, that was a crazy one yesterday. A big fight for the caboose.
74 people were on the monetary monorail. It was so tired last night, Creed. It was ridiculous. All right, guys, we love you. We'll catch you again for the next one. Until then, case closed, baby.